Good evening, everyone. My name is Paul Bakota. I'm college class of 87. Thank you all for joining. I'm a board member of the Harvard Club of Southern California. And so on behalf of the club, there's nothing great to say for people who have been affected by the fire. So I wish I had something more intelligent to say, but unfortunately I don't. I just want you to know that that all of us, David and I, and obviously the members of the Harvard Club, are very sorry for anything you may be going through. And we're trying to do a variety of different things that we hope will help at the margins for people. One of them being this kind of Zoom call to see if we can provide some information. So I'm going to introduce David in 1 second and also just kind of help with the mechanics. So we'll have over 150 to 200 people. We had over 350 people sign up. Some may just listen to the recording, but we're going to have a lot of people on. So it's going to be logistically a little bit challenging. And I will confess, I'm not like the Zoom master guy at doing this. So we're going to do the best we can. What we're going to do is we don't have a Q&A feature enabled on this because it's a different type of license than the club has. So if you have questions throughout the event, chat them directly to Alt Zoom host, which is me, or Alt host Zoom, which is me, because otherwise, as you know, the chat will get really crowded and it's too hard to get information. So if you could send that to Alt host Zoom, which is me directly, I'll try to curate questions and then David will speak for about 25 to 30 minutes to give information, and then we'll start some of the questions. We will obviously not get to all of the questions, even if we go over time. So in that case, what we're going to ask you to do, the chats are saved on the Zoom call, and we can access that. But I'm also going to provide my email in the chat, and then you can send me an email with your question. And if you could put in the heading Zoom fire meeting, just that way I can find it, and I'll put that in the chat as well. And then I'll batch these emails and send them to David. But obviously, with this many people, his ability to respond is going to be limited, and also, kind of David's ability to provide advice to individual homeowners concerning, your claims, your policies, is limited, and as is his ability, unfortunately, to take on additional specific clients. So what we're trying to do is do this Zoom meeting so David can reach out to as many people as possible and get this information out to you. And then we will take questions by email and through chat and try to get back to you as much as we can. But depending on how many questions we get and how many emails we get, that may be difficult. So we're going to do the best we can to answer the questions. Hopefully the information David provides up front will answer a lot of those questions. And then we're going to just do the best we can with this many people. So again, I apologize in advance if some of this seems kind of wonky or not as efficient. We're trying to do these quickly and go from there. So let me just quickly introduce David Thomas. He's a 01 graduate of Harvard Law School. He's a senior partner in the Los Angeles office of Blank Rome LLP, and he's a member of the firm's nationally recognized insurance recovery practice, and they exclusively represent policyholders. So David only represents people in conflicts with people and companies in conflict with insurance companies. So we have him on. So I've said enough. I'm going to try to go in and send some of that information in the chat, but I'm going to be quiet and let David start talking.
Hey,
David, it's
Paul,
all yours. Thank you.
Paul,
Yeah.
Before that, so we are testing actually a new feature.
Oh, I'm sorry.
On Zoom. And so if you guys can stay on until Paul actually ends the meeting for all, that will help us test a new feature in Zoom. So if you can stay till the very end, we would really appreciate it. Thank you.
That way we can let more people in. So sorry,
is it?
Karen, you
An
only
hour.
asked me to
But
do
we can just, it's on my phone, so I can just move it to the house.
An hour though?
It's an hour long, yes.
Yeah. So okay, could everybody? I thought I had everyone muted.
We'll
But
be
if
home
everyone,
by 7 though.
okay, if everyone could mute. Hang on, I'm trying to mute everybody. But if everyone could please mute.
Mute.
Sorry, hang on. I'm just trying to do the mute. Karen, do you see the mute all?
Yes, I do.
Okay. Okay.
Did you mute all?
No.
Do I need to do it?
I did, but it seemed to be someone escaped. Okay, so why don't we go ahead and get started? David, sorry about that.
No problem. And Paul, thank you very much for that introduction. And I want to thank the Harvard Club of Southern California for inviting me to speak to everyone. And special thanks to Paul and Karen Hernandez, who have put this together, and we couldn't have done this without them. So thank you all. As Paul mentioned, I graduated from Harvard Law School in 2001. And the 3 years I spent at the law school were truly extraordinary. I had incredible professors. Justice Elena Kagan taught me introductory constitutional law, and wonderful classmates. And I was actually back there on both the law school and the undergraduate campus just 2 months ago, and was reminded how wonderful of a place it was. So I'm very pleased to be speaking to the Harvard community. The wildfires earlier this month, so much has been said and not enough. It is truly the Hurricane Katrina of Los Angeles, and the devastation is just unspeakable. Apart from the financial losses, which are severe for many, even the less tangible losses are just irreplaceable. I was speaking with a client yesterday who told me who lost his house in the Palisades fire, and he talked about losing the poems that he had written for his wife of 35 years. So you can't replace that with money, and this tragedy is truly an unspeakable tragedy. So I am sorry again for what everyone has been going through who's on this call. But tonight, I'm hoping we can talk about at least some way to recover financially to some extent, hopefully almost the whole extent, for what you've lost. And that, of course, involves insurance here. My goal with this talk is to make the process, the claim process, a little bit less daunting for you all, to help give you the tools to help manage your ability to pursue your claim. The truth is, even though I'm an insurance recovery attorney representing policyholders, in my view, only rarely do you actually need to retain a lawyer or even consult with a lawyer. You have the ability, with some assistance in certain situations, to really pursue your claim and get complete recovery. So the format tonight is I'm going to try to speak on general concepts and the overlay of the law where relevant for about 25 to 30 minutes. And then after that, as Paul mentioned, we'll be opening it up to questions and answers. So before we start, a little bit about myself. Again, I'm an '01 graduate. I've practiced for almost 25 years, exclusively representing policyholders, both in Northern California and in Southern California, and I have a national practice. I'm a partner in Blank Rome's Los Angeles office in Century City. And most of my practice involves representing corporations and institutions on commercial lines of insurance. You may have heard of commercial general liability policies, directors and officers, and the like, and other unusual coverages as well. But I also represent individual homeowners, individual policyholders on homeowners policies, including in natural disasters and wildfires. And I am litigating right now against an insurance company for a homeowner. So I do have experience in that area, and I was hoping to impart some of that here tonight. So jumping into all of this, let's start with some of the basics about the relevant coverages that you have in homeowners policies and renters policies, and then talk about some of the typical policy provisions you have there. Now, this may be old hat to a lot of you. You may be a few weeks in familiar with all of this, but I want to make sure that we understand the basics here before we start talking about things like the claims process, best practices, the overlay of some of the key statutes and regulations, and then finally, some of the types of individuals or entities you can call upon to assist you if that's helpful in the claims process. So let's start with the relevant coverages. I want to start with a key point that is critical for everybody to understand here, which is that coverage, both the grant of coverage and the limitations on coverage or the exclusions of coverage, begin with the plain language of the policy, of the actual insurance policy. So there is an overlay of statutes, regulations, the common law that apply, but you have to start with your policy language. And this is why, as I'll talk about in a moment, about best practices, it's critical to get a copy of the complete copy of your insurance policy. You've got to look at the actual language, and you can have radically different outcomes between different homeowners who are policyholders, depending on the language and terms of their policy. There are some standard provisions in California. California has a standard fire insurance policy, but the actual coverages vary depending on the issuing insurance company. When you get a copy of your policy, the first page, or maybe multiple pages, are called the declarations page or pages. And those list out a lot of the basic information, including the types of coverages that you have, and including something known as coverage limits. Coverage limits are the maximum that the carrier is going to pay for a loss within that particular coverage, subject to the specific terms that are laid out in the policy. Now, some of those coverages have sublimits, right? These are lower limits within that coverage. So a typical one you might see, for example, is artwork. Oftentimes, there's a sublimit where even though you have a certain amount of coverage for personal property, also known as contents, coverage for art or artwork may be limited to a much smaller amount. So there's both limits and there are sublimits. So let's talk about some of the basic types of coverages for real property. So the first one is dwelling. Right? Dwelling is your house, your main house. It's where you live. And typically you will see there a line for replacement cost or extended replacement cost. Now we're going to talk in a few minutes about the difference between replacement cost, actual cash value, but most of these policies cover the cost and based on certain conditions for you to replace or repair your home. And so you will see a limit for replacement cost. That's the maximum they're going to pay. You may also see something called extended replacement cost. Extended replacement cost is an additional amount. It could be 10%, 20%, 50%, even 100%, depends, of an additional amount over that limit that the carrier will pay if your cost of replacement is more than that. Why? When you have widespread disasters like this, the cost of rebuilding and replacement often jumps up for everybody. And so what in normal times, if your house was the only house to burn down, might be sufficient coverage, you need additional coverage. So that's replacement and extended replacement cost coverage for your dwelling. There is something called code upgrade or rebuilding to code coverage. It depends on the policy. That's where if you have a house that was built a few decades ago or longer, and now if you have to rebuild your house, there are you can't replicate your exact house because the building code has changed and you may have to have fireproof windows or some other alterations there. The insurance company will offer, depending on the policy, additional code upgrade coverage or rebuilding the code coverage. That's usually an additional amount. And there's certain requirements sometimes. You'll see other structures. Okay, other structures are like a dwelling, but it can be a detached garage, it can be a shed or something else, it depends. And usually that limit it could be 20% of your dwelling limit. It's laid out there as well. So that's another real property coverage you have. There are other coverages that may or may not be set out in the declarations page, and you have to really read the body of your policy. So it may cover, for example, land. If you have to do something where there is stabilization needed for the land or some sort of remediation, depending on certain conditions. There may be landscaping, if you have trees that burn and so forth. So you have to look at your policy. There may be these additional coverages. Those are typically the real property coverages. Personal property is another coverage, and it's also known as contents. So you hear personal property or contents, generally not fixtures, right? But this is everything inside your home. With the renter's policy, these will typically be lower. But that, again, it depends on the policy that you have. They could be very substantial. It could be more than you could ever think of buying. It could be a lot less. And remember, there are potentially sublimits to those. You also may have an additional coverage depending on the policy. It may or may not be set out in the declarations page for mitigation or remediation or temporary repairs. Needless to say, if your house burned down, that may not matter right now, but that's an additional coverage. There may be an additional coverage for debris removal. That's something a lot of people are talking about now with the announcements from the county, the Army Corps of Engineers, et cetera. But debris removal may be an additional coverage, or it may be included within another coverage. And that's, again, one of the things you want to check, which is if you have a limit that encompasses different types of coverage, you may erode or waste or burn, as we call it, the limits on that coverage. So you have to check your policy to see what the effects are, if there's a payout for debris removal and so forth. The last common coverage that we'll talk about is called loss of use. And often you hear about this as additional living expenses, or we call it ALE for short. You'll hear ALE a lot. Sometimes you'll hear if you didn't occupy your home, but you rented out, there may be fair rental value, which is sort of like that. But most people are dealing with a loss of use type of coverage, or ALE. And that's the idea is when you can't inhabit your home, it will pay for you to maintain essentially the same standard of living elsewhere. That's typically going to be either staying at a hotel or a temporary lease somewhere. But it can also include things like if you're having to order in or go out to restaurants because you don't have a kitchen to cook at home and you're spending that much more for food, that overage may be covered under loss of use. If you have to board your pet dogs or something like that, that may also be covered. Things like that would fall within loss of use, again, depending on the terms set out in the policies. So what I've just described are, as a general proposition, the typical kinds of coverages you're going to find there. So let's talk about briefly some of the common provisions and conditions you will find in these policies that govern the payment of these proceeds. So we'll start with the general concept, which is that of an open policy versus a valued policy. And the most common type of policy you're going to have is an open policy. It may not say open policy, but that's how the law looks at it. That's how the insurance code looks at it. And the basic idea with an open policy is this is a policy where the replacement cost of the structure, typically the dwelling, is not predetermined. It's a replacement cost, which I'll talk about in a moment, has to do with the cost to repair or replace or rebuild that structure that's been damaged or destroyed. It's not determined in advance. That's an open policy. That's the vast majority of policies that you're probably going to be dealing with. Some policies are called valued policies. And by the way, there are different flavors or species of valued policies, but a valued policy means that in the policy, you and the carrier have already agreed essentially what the cost is to replace the house. So there's no guesswork in that. And I've talked with some folks who have valued policies, and the carrier, upon determining a total loss, is prepared to pay that set amount of money. But that's the minority. The vast majority of these are open policies. And the question then is, what do you get and when do you get it? And for that, you're going to want to look at the loss settlement provision. It's called loss settlement. And in that, you come into concepts of replacement cost versus actual cash value. Okay. And by the way, California law mandates that on the type of policy, there's usually a page in the back, and it's like a check the box kind of page that tells you the payment basis here. So these loss settlement provisions, sometimes called payment basis provisions, will tell you what you get. So a replacement cost is the most common. And that is the least of the cost to repair, rebuild, or replace your lost house. Okay. And I'm going to talk in a moment about special circumstances if you have a total loss, like many folks have had. But it's basically if you could rebuild your same house just as it was before, that's going to be the replacement cost. But if you could repair it, if it wasn't a total loss, and you'd spend less money, that would be the replacement cost. It's the least of the amount. And replace is sort of a murky term, which has special application if you replace by buying or rebuilding elsewhere, which I'll get to. But it's the least of the cost to repair, replace, or rebuild. It's usually the maximum amount of what your loss is going to be. Actual cash value is the depreciated cost. So it's really in theory the depreciated cost of that structure, or it could be your personal property at the time of the loss. So let's say you have insurance for $1.7 million and your normal replacement cost would be $1.6 million, okay? Your actual cash value at the time of the loss for the house may be $950,000 because of depreciation over time. What's key is that you have to read the terms of your policy, because the most common situation, not exclusive, but a most common situation is the insurance company pays actual cash value once it ascertains that amount when you've had a loss, and it only pays the additional amount that tops you up to replacement costs when you've actually repaired or rebuilt or replaced your home. There are policies that do just pay replacement cost, even if you don't actually rebuild or repair or replace your home. Those are less common. The premiums tend to be a lot higher. And the battle with the insurance company is often determining what is the cost to rebuild or replace if you don't actually rebuild or replace your home. If you actually rebuild or replace your home, it's often going to be what you spent out of pocket, but the insurance company may push back and say, look, you spent, $1.7 million to rebuild. You could have done it for $1.4 million, and that's all we're going to pay you. And that's a fight. But the main thing is to understand whether you have an obligation to actually rebuild, replace, or repair your house in order to collect the full amount, or whether you just get it automatically. Another term in connection with that, and we're going to talk about this further in terms of the statutory overlay and the regulatory overlay for this, but one of the key things to pay attention to is time limits. You have to scour your policy carefully. Sometimes policies say you have to tell us, the insurance company, your intention as to whether you're going to rebuild or replace or repair your home within 180 days, or we're going to cut off additional living expenses, for example. Or you just have to get it all done by a certain date, or you have to start it by a certain date. The rationale, which is not crazy, is that they don't want you to just be sitting out there and not doing anything to rebuild or replace your home. You have to act with diligence and dispatch. So you have to look very carefully, both at the time limit that they'll pay the coverage, time limit to complete a repair or replace, the time limit that's specified in the policy for actually giving notice of intentions or commencing work on something. By the way, and we'll talk about best practices, you can ask insurance companies for extensions on that. And you can say, look, I know I've got this provision for 180 days. I need more time. Can you agree to extend it by another 90 days, for example, and do it in writing? They can extend these periods. They're not, absolute, but you need to read your policy. I can't emphasize it enough, and identify. Anytime you see something that refers to days, weeks, years, or whatever throughout it, take a look at that and read it carefully. So we've just talked about the basic coverages. We've talked about basic concepts and key provisions here for you to go through. Let's talk now about a general overview of the claims process, which I think probably most of you have a flavor of by now and have experienced, but I want to make sure we understand all of this and we're on the same page, including in use of terminology. And then we'll move on and talk about some best practices here to help maximize your ability to recover. All right, what's the basic claims process? You start out by giving notice of the claim, whether you directly or your insurance agent. We'll talk about it in a moment, but you give notice of the claim, which everybody here or everybody they know who suffered a loss has done by now, presumably. You notify the insurance company. The insurance company then appoints an adjuster. And the adjuster is basically the claims handler. And I'm going to get to the specific terminology in a moment, but the adjuster is the claims handler, or there may be multiple adjusters. That's the individual at or for the insurance company that is adjusting the claim along with others. What does adjustment mean? In the insurance context, adjustment means investigating the claim, evaluating the claim for coverage, determining how much should be paid, whether any coverage should be denied or limited, and then ensuring that payment actually gets made. So it's the entire process of handling the claim to the end where they finally pay out and take a position, including taking positions in writing. That is part of the adjustment of the claim. And the insurer is supposed to pay the amounts that are due that are not in dispute. It can't just sit on payments. If it agrees that you're entitled to X amount, it needs to pay that actually within 30 days. And it can't force you to sign a release in order to get that payment. But that is part of the whole adjustment process. Let's talk about terminology here. Very important to understand what each of these terms refer to. Start with the adjuster. Okay, you'll hear the term adjuster or independent adjuster. I want to put that on one side of the ledger versus a public adjuster. A public adjuster is different. Talk about that in a second. Adjuster or an independent adjuster represents the insurance company. When you hear independent adjuster, that adjuster is not independent. All it means is they are contracted with by the insurance company to do the work of adjusting the claim. They are individuals, they need to be licensed, they work with a company. Some insurance companies have business models where they always outsource their adjustment to a third-party independent adjuster. Some of them may have lots of a whole set of employees, but when you have a catastrophe of this scale, they have to bring in people who are independent adjusters to work for them, okay? You may not know the difference because some of them are assigned email addresses. So if it's Chubb, you may have johnsmith@chubb.com, even though John Smith works for such and such agency and is an independent adjuster. For your purposes, they represent the insurance company. Also be aware that a lot of them are coming from all over the country. They may be from the Midwest, they may be from the South. This is potentially problematic because, as we all know, real estate in Southern California, especially on the west side of LA, is truly astronomical compared to other parts of the country. So you may have adjusters who are in there who are even supposedly very experienced, who are experienced with adjusting properties in, let's say, the Chicago suburbs, and they don't understand how much it really costs to build in Southern California or how much it costs to get a rental property temporarily. So you should be aware that you may have adjusters who are independent adjusters who are there for your company, and they may not be familiar with all of this, but they work for the company. So it's adjusters and independent adjusters. Then you have public adjusters. Public adjusters do not work for the insurance company. They work for you. So public adjusters, some people call them private adjusters, but the term is public adjusters. They are licensed in the state of California. They compile your claim, they value your claim, they have access to different experts. They handle your claim, they present your claim, and they advocate for your claim vis-a-vis the insurance company. They represent you. And it's in exchange for a cut of the recovery. Tips standard is 5%. I am hearing 10%, particularly one well-known public adjusting company is 10%. I've also heard 8%. So it's going to be a range between 5 and 10%. And at the end of the talk, I'll give you my thoughts about whether you need one or not, but you don't necessarily need a public adjuster. You can handle them yourself oftentimes, but that's what a public adjuster is. It is different than just a garden variety adjuster or an independent adjuster. You'll hear the term vendor thrown out. Vendor just means any kind of individual or entity providing services. So if it's a remediation type of service, you'll hear, oh yeah, we contracted with the vendor. That's what that's referring to. You'll hear it. Insurance agent. Probably everybody or most people have reached out to their insurance agent. There's brokers and there's insurance agents. In the law, it's a little bit fuzzy. Sometimes there's licensing requirements. Generally speaking, a broker represents you. An insurance agent, it represents the insurance company. You'll hear a captive agent. That means they just work for that particular insurance company. Maybe they just work for State Farm or Farmers, for example. Insurance agents may be useful for kind of as conduits of information, but they're really more in the placement of coverage. They're not technically involved in the handling of the claim, but if you have a good relationship with them, they may be more involved. And then finally, you may have coverage counsel, an attorney. Coverage counsel is like myself. It's less common. Coverage counsel really is involved with figuring out legal issues and interpretation of the policy, as opposed to quantifying and pulling together your claim. So those are the players in the claims process. Best practices. I feel strongly there are 3 critical things you all should have in mind. Everybody should have these in mind. And if you follow this, you are most of the way there. The first thing is, as I said at the start, get a complete copy of your policy right away. Ask for it in writing. They have to give it to you within 30 days under the insurance code. Don't just get the declarations page. Just don't just get a summary of coverage. Don't just get your agent saying, oh yeah, I think this is what you have. It doesn't fly. You need a complete certified copy of your policy from the insurance company directly. Because as I said, that's going to be the start of your coverages. Number 2, let me just preface this by saying, I litigate against insurance companies every day. I sue insurance companies for bad faith. I've seen some egregious practices. That said, I strongly encourage you to treat your insurance company, including the insurance adjuster, as a partner, and specifically go to them for advice and guidance. Doesn't mean you take it as gospel. They are supposed to partner with you. Under the law, they cannot give the insurance company's interests any greater consideration than yours. You want to communicate with them as much as possible. The vast majority of these people who are involved, whether independent adjusters or captive adjusters for the insurance companies, are people trying to do the right thing. They may make mistakes, but they're trying to help. It's important to have the communications for several reasons. One is, first of all, they do appreciate your keeping them in the loop and asking them questions and getting recommendations. You can ask them for recommendations on anything. It helps them be engaged. And you actually often do have the expertise from them that will be helpful. Number 2, it's a protective measure. Okay. If they take a position on something that is beneficial to you, and this is, I'll get to the third point in a second, which is documenting everything. But if they take a particular position on that, that may be very beneficial for you if they change their mind later. So you need to make sure that they're taking that position. Also, if you're thinking about doing something under the policy, like going out and buying property or going out and buying personal property, whatever it might be, or you're thinking about resolving the matter in such a way, you want to run it by them, because that prevents them, if they approve it, from a gotcha later on. And some of it is just unavoidable when it comes to actually the amount to rebuild or replace the home. So communicate with them, rely on them. But with the one caveat, ask them for this information, but take it with a grain of salt and verify it. It is not gospel. You can ask them what the coverages are that you have. You can ask them about the limits. Take that for what it's worth, and then you can do your own homework or consult with somebody else to verify. It is not gospel, but it's important to get that information. The final thing is, as I alluded to, document everything, okay? Everything. Being hyper diligent is key. So if you have a telephone call with an adjuster, thank them, write a confirmatory email that is as specific as possible, send it to them. Thank you, John Smith, Jane Smith. I appreciate our conversation. Here's my understanding of what we discussed and what you've advised and what you've told me. Please let me know if any of it's incorrect. If not, I'll proceed on the assumption that that's all correct. Okay, you can do that. You have a conversation. Otherwise, take careful notes, like a diary. You can create a diary of that, or a journal that just addresses things with as much specificity. Date, time, who's in the call, what specifically was said, as much as possible, obviously within reason. But take that down. That includes conversations with third parties. That includes conversations with your own insurance broker, with your public adjuster if you've retained one, your own contractor, the city of LA, whoever it might be. You should have a diary, because at a later point, you may have to, number one, you may have to show diligence in reconstruction. That is usually a prerequisite to extending periods of time and other factors, but you want to have a comprehensive narrative of what you've done to be diligent. And it also helps if unfortunately things go south and you end up in litigation, there's some kind of a claim dispute, you have a complete replication of what exactly took place. So be hyper diligent, document everything. Okay. That also means if you're putting together and gathering information about reconstructing your home, you want to gather documentation. So if you have copies of as-built, for example, everything about your home, photos you might have, videos of things, whatever you can possibly find, gather that documentation in addition to documenting conversations in real time. So you will be rewarded for being hyper diligent about collecting information and documenting everything. So now let's talk about some key statutes and regulations, and then I'll wrap with kind of alternatives about individuals and companies that can assist you with this. I just want to say again, you can go on to Google, you can Google these statutes, just Google California Insurance Code and some of these. There's plenty of resources. You don't have to be a lawyer. All right, dwelling coverage. One of the most important insurance code, California Insurance Code provisions is section 2051.5, 2051.5. Okay, that applies to open policies, 2051.5. And that has some key provisions, okay? It says, at a minimum, the carrier is supposed to pay you actual cash value. And if the policy says you have to actually rebuild or replace to get the full amount, then you have to do that. But they got to pay you actual cash value once they ascertain that. So they can't just sit on the actual cash value. When you have a disaster like this, you've got 36 months to rebuild or replace, and then they can extend it by 6-month increments if you've been diligent. So you have this time limit when you have a natural disaster, and then or declared emergency rather. And then finally, this is a key provision. If you've had a total loss of your home, you can rebuild or replace your home elsewhere. You could buy a different property, you could rebuild elsewhere. The key caveat is if you have replacement cost coverage, you're capped at what you actually would have gotten if you had rebuilt or replaced your home there at the site. So if everybody in the world agreed that it would be, $1.3 million to rebuild or replace your home, that's the maximum they're going to pay out, even if you went and bought a house for more elsewhere. That's also subject to, you're going to be subject to the limit for that in the policy. This actually, I'm giving you the simplified version. The actual statute talks about things, replacement cost, extended replacement cost, code upgrade, and so forth. So you get kind of the bundle of all that. But you're going to be subject to the same terms as if you rebuilt it there. So if you actually have to rebuild or replace, you've got to do that to get the full amount. By the way, if you're thinking about buying property elsewhere, and there's no deduction for land value, which is helpful, you want to confer with the insurance adjuster. So if you're saying, hey, I'm going to buy this property, and are you going to pay that? Get buy-in from them first. And some people have talked about buying a much smaller place, whatever, temporarily. Make sure you're clear with the adjuster that that's not your replacement of your home. That's a temporary thing. You don't want them to say, hey, you spent $500,000 less and you're stuck with that. That's the replacement of your home. And you said, no, I'm doing something temporarily. That issue actually comes up from time to time. That's the key dwelling provisions. In personal property and contents, and then I'll also talk about ALE, additional living expenses. For personal property, 2061, insurance code 2061, that is a key provision there. That basically says if you've got a total loss of your primary residence and there's a state of emergency, declared disaster as we have here, one of the key parts of it is you're supposed to try to itemize your loss of your contents, your personal property, but this says if it's not practical to do that, you can kind of group them. Clothes, even says CDs, DVDs, so you get some leeway, and you can also use your own. You don't have to use the insurance company's form. There is also an insurance regulation that's important here. If you have a total loss of your home, then under the regulations, you are entitled to receive 30% of your dwelling limit for your loss of your personal property, but it is capped at $250,000, and it's further capped at whatever personal property limit would be in the policy. So let's say you had $1 million for your dwelling limit. And you had a total loss of your home. The carrier would need to pay you outright. In theory, it could be $300,000, which would be 30%, but then that would be capped at $250,000. And then if your policy had a limit of 150,000 for personal property, you'd get 150,000, and they should write you a check for 150,000. But that only applies if you have a total loss of your primary residence. So just keep that in mind there. In additional living expenses, insurance code 2060 is helpful. Says you basically, if you have a state of emergency here, 2060 says you get it for up to 24 months. And then if you've been diligent about trying to rebuild or replace your house, it can be an extension of up to 12 months. So you could have 36 months. That's probably going to be standard anyway here. Insurance code 2061, again, that I mentioned, has a very helpful ALE provision. 2061 says, if you've had a total loss of your primary residence and there's a state of emergency, as we have here, the carrier has to advance you 4 months of ALE. So if you are thinking about signing a lease and you want to run it by the carrier, because there has been some pushback from some carriers saying, no, that's too expensive of a accommodation. Everybody is saying, have you opened the papers, or I should say, look online at the papers. Everything is astronomical right now. So there could be a fight there, but let's say the carrier agrees that you're about to sign a lease for a year, and there's a certain amount for the rent. You can, and it's on request, you can tell the carrier, under 2061, I'd like you to advance me 4 months rent. It's not limited to rent. I mean, you could say if you're spending, you can show you're spending more money on food than you otherwise would, you could do that as well. But you can get an advance of 4 months, and then the balance can be what's incurred. So don't forget that. Last governmental provision, which is not really about payment, but everyone's been asking about, the moratorium on cancellations, which goes to sort of early June 2026. Unfortunately, that is limited to policies that were in force at the time of the loss, including policies where there was a notice of cancellation, but the existing term had not finished. That applies. But if the carrier has canceled already, you cannot revive it. I talked to 2 homeowners who had their policies canceled 7 days and 10 days before the fire hit, respectively. And unfortunately, that moratorium doesn't help that. So even if it's a day before, it doesn't help, unfortunately. Now, finally, in terms of people who can help you with these claims, you have a few different options. You could use none of them, or you could use all of them. It depends. And I don't necessarily advocate for them. It really depends on your particular situation. One is sort of as a basic matter, the insurance broker or agent often is your first point of contact. Often that's more as a conduit of information. So when there's been a loss, most of the people I talk to say, yeah, the first person I called was my insurance agent, and they put in a claim. A lot of insurance agents either lost their own homes or are unavailable, so don't be surprised, and you can reach out to the carrier directly. But if you've worked with a broker or an agent who has some familiarity, you can do that. But remember, they really place coverage as opposed to the claim. You can work with a public adjuster. Public adjusters may be very helpful for people who have very complicated claims. They don't have a lot of people they know already, like licensed general contractors to work with, or they need help with itemizing things. They can be very effective. Sometimes they are not as effective. There are a lot of people holding themselves out as, they are public adjusters, but the performance is uneven, put it that way. And so it's a really a individually dependent situation, especially if you are incredibly busy with work or otherwise. You may not have that time to collect all of your information, itemize it. You may not have access. So that may be the way to go. If you do retain a public adjuster, you should document all of your communications with them. Public adjusters may just directly work with the insurance adjuster, and they may resolve things on their own if you're not vigilant. You want to make sure you have a seat at the table and you're involved. They are your agent, but just like with any principal agent problem, especially where they have a cut of the proceeds, they may be incentivized to get most of the claim but not go the extra mile. Some of them are very good and will go the extra mile, but you want to stay on top of them. You want to document your conversations with them. You probably want to tell them, please do not communicate, don't agree to settle or pay anything on the claim or have the insurance carrier pay anything on the claim without running it by me first and approving. Or if you're going to send something significant, run it past me first and approve it. And that will help avoid disputes in the future. Contractors, if you've worked with a licensed general contractor or another expert or consultant, you can reach out to them directly, particularly if you're thinking of rebuilding and you have someone in mind, you want to work with them, reach out to them right away and document what you've done because you want to show diligence. It's especially helpful if you've had a total loss to have a licensed general contractor who's a builder, who actually builds homes in addition to remodeling and so forth, because they will help put together the claim if you have an open policy and say, here's what the repair replacement cost is. And they will joust with the insurance adjuster and the insurance adjuster may have their own consultants in terms of what it costs to rebuild a house. And they will know how to speak insurance companies speak. If they have that experience, they will know the proper line items. There's a whole way that they do it. They will know what the cost of, drywall, lumber, steel, framing, that kind of a thing might be. They will know how to put in things called soft costs, which could be 10 and 10 for profit and overhead, for supervision, which insurance companies always like to fight back on and attack the cost of the soft costs. So if you have somebody in mind who's experienced, you can work with them. Coverage lawyers like myself, you usually do not need a coverage lawyer. My sense is, my gut is, with all the focus on these wildfires, insurance companies will mostly be on their best behavior. But coverage lawyers are much more in the realm of interpreting the policy, helping you if the carrier's denied coverage or said you don't have a certain right or you have to do this and that. The coverage lawyer may be involved on that and can litigate if necessary. The evaluation, the sort of factual pulling together a claim, how much something costs, the mechanics, the inventorying, that's not usually what an insurance lawyer does, a coverage lawyer. That's also usually not very cost justified. I have quarterbacked really very, very large claims and in litigation, but usually it's got to be a really, really huge loss and a huge dispute with the carrier for the coverage lawyer to be in that role. The coverage lawyer is more advising on the law and policy interpretation if there's a true dispute. And then finally, one thing you can also do is if you're running into non-responsiveness from the insurance adjuster, is you can go to the California Department of Insurance and file a complaint. They are going to be overwhelmed. You should not expect that the Department of Insurance is going to actually go in and get you everything that you're looking for. Their best value, in a way, is to pass on your complaint or your inquiry to the carrier and make sure that they actually respond. So you send a complaint, they will forward it to the carrier. I think they have 21 days under the regs to respond, and that will shake the carrier loose and give you an official response. Normally, the carrier has 15 days to respond to you under the regulations, but this is sort of an extra hammer. But you should not expect that anyone from the DOI is going to come in and kind of get your claim. So that is probably too much for the amount of time that I spoke. I know a lot of it is old hat for you all by now. I hope that was helpful. And so why don't we pause and open the floor to questions, and I'll try to do my best to answer them.
David, thank you so much for all that. Super helpful. A lot of obviously information. So thank you, most importantly. And then what I'm going to do, I've received a lot of questions. I'm trying to hit the ones that are, I think, going to be most applicable to the greatest number of people. Some of them are really, really specific, so we may not get to those. I put my email in the chat, paul.bokota, BOKOTA @gmail.com. And if you send me a question and have in the subject line Zoom fire question, then I can try to group those and send those to David. So let me start though with a couple of people have asked. You mentioned getting a certified copy of the entire policy. So is that a term of art? What does that mean that it has to be certified? Should you get that before you file a claim?
Sure, and actually certified is not necessary. Sometimes insurance companies call them a certified copy. You could just say an official. You just say, I want a complete an accurate copy of my policy. That is sufficient.
Okay, and is it okay to file a claim and contact your insurance company before you get that, or should you get that first?
Absolutely. And just to be clear in terms of terminology, when we talk about filing a claim, it's really just a notice of a claim. I mean, you're just giving notice. If you look on your policy, they may say either you have your insurance agent will just pass it on. Sometimes on the cover, it will say, send any claims to, and they'll give an email address, and you just send it and say, here's my policy number if you have it. Here's my property location. Here's my name. I suffered a complete loss. Please, I'm giving notice, and that should be sufficient.
Okay. And in terms of the ALE, there are a couple questions on what if there's not a total loss, and then perhaps if you just have smoke damage or damage that's not a total loss, how should people think about the ALE issue in that context?
Right. So, I mean, the ALE is, so you wouldn't get the 4 months automatic advance, which is for total loss, but ALE is really supposed to be for any time your home is basically uninhabitable. I mean, there's some differences at the margins, but for this situation, a number of folks have suffered, I've talked to have suffered significant smoke damage. And we know that a lot of the ash there is toxic, and it's not just wood being burned. So these homes are not habitable. Your ALE entitlement is the same there, but you want to talk to your carrier about renting a comparable place. Most policies say they're going to find that you're entitled to a living arrangement that is basically comparable to what you had before. So and it'll be up to the limit of whatever they're putting in there. So if you're trying to find a comparable location or anything that you can find at all, try to run it down. You can send it to your adjuster, say, I would like to rent this or sign a lease here. It could be even at a hotel. By the way, most insurance companies do want to get you into signing a lease because it's cheaper than a hotel. But here, because of just the craziness, it may be more expensive for a lease than hotels with the price gouging limitations. So go to them, say, this is what I'm thinking of doing. If there's any pushback, you can even find comparables online and say, this seems to be fair. Please approve this. And
Okay.
they will typically want to have proof that you're actually incurring that.
Because some people obviously will be out, may not have a total loss, but because of smoke damage, may be out for months or many, many months. So somewhat akin to a total loss. Okay, helpful. I'm just going through some of the other ones. One thing I guess in general also maybe talk, because we had a couple questions on this about mortgages. So one, what happens with respect to your mortgage? And then one specific question was, can the bank, are they allowed to take insurance funds and hold them without investing for the homeowner until the rebuild begins?
So it really depends on your situation. First of all, if you have a mortgage, and most do, you should go to your mortgage company and ask for forbearance. I think most of the major mortgage companies are offering forbearance. I can't remember if it's 60 or 90 days right off the bat. But generally, if you have a mortgage, your insurance policy will identify them as a loss payee. And what ends up happening is that when the insurance carrier sends the check, and they sometimes do it a little bit differently, they will put both your name and the mortgage company's name on it. And they will often send it right to the mortgage company. It depends on the provision. And so you have to go to the mortgage company, which have departments that deal with this. Usually they're reasonably cooperative, and get them to sign off on that. It is usually a discussion with the mortgage company where they want to see that those funds are going towards repairing or replacing your home. They shouldn't withhold this from you, but they're entitled. They kind of, based on the terms of your mortgage, could have first dibs. But what I've seen is that generally they will cooperate with you to make sure they endorse it over to you, and then they'll want to see that you're rebuilding or replacing, but you want to have a conversation with them. But right now you should try to get them to forbear.
Okay. And then I had a few other questions. I think this is going to be relevant for many people is, if there's a standing structure in the middle of a large burn scar, what are some recommended ways to prove that the house is uninhabitable, even if it's there? Like, how do you prove how much smoke there is, or are there broken windows, or all the homes around it are damaged? So if your house is there, but obviously the area is severely troubling, how do you prove that you can't get in, and what are the ramifications of that?
Yeah, and actually, I talked with someone who had that exact same situation. A lot of this stuff comes down to these key rules, which are the best practices, is to communicate with your insurance carrier, with your insurance adjuster, and to document everything. So first of all, any attempts that you've made to try to access the property, you should write that down in your diary. You should go to the insurance carrier and say, hey, or your insurance adjuster, hey, this house clearly has serious smoke damage, toxic effects. What are you going to do to remediate that and test this? Because especially I have small children, I don't want to put them at risk. What do you recommend we do? And are you going to send out experts? You can go on your own and try to retain your own experts if you can. Again, I was just speaking with someone who was inclined to do this, and it's either through a public adjuster who may have connections to testers for hazardous materials, or other people you may be in contact with, and you can get them in there and test and see if it's the kind of thing that cannot be remediated through just cleaning. The insurance companies are going to want to, just pay to remediate it as opposed to just basically tear it down. But you can hire your own experts to kind of advocate for your review. One of the carriers, I think, has been sending one doctor, one expert in this area who's licensed to go to all these homes and is very familiar with all these issues. But there will be a thumb on the scale to remediation, so you can take whatever steps are appropriate, but you should ask them for what they recommend and what they're going to do.
And is that true? This came in. Is that true even when toxic ash is not explicitly stated in the policy? I think there are some concerns that if the policy doesn't specifically state that this makes it uninhabitable, are you out of luck? And it sounds like you're saying even if the policy doesn't state that, you could have an expert come in and say, look, I don't care what the policy states. This house is not inhabitable. The toxins in the air are X percent. Okay, so even if it's on the policy, you're not necessarily out of luck. There's a way around that with the appropriate expert.
Yes, it's got to be habitable by normal standards.
Okay. And then this is a general question, and I know you talked about this a lot, but I think this is always one of the most confusing things for people in general. How do the insurers determine whether repair, replace, or rebuild? And is that their determination, or kind of how does that practically happen?
Sure. So I should start by mentioning there is, in the normal course for these policies, there's something called an appraisal provision, where if you have your own expert and the insurance company has their own consultant, and there's a dispute over the valuation for all that, you can go through this streamlined process. It's almost like an arbitration. That is not, they cannot compel you to do that when there's a state of emergency here. So you can avail yourself of the appraisal process, but it's typically not advised. The way it does is they have their adjusters and they have their own consultants who will go in there and make determinations as to whether the property, I mean, like if it burned to the ground, that's clear, but whether the property can be repaired in certain instances, whether something needs to be rebuilt in part, any other steps. They will be looking at what amount is the cheapest for the insurance company. Many insurance companies, if it's a close call, will err on the side that will be beneficial to the policyholder. So the insurance company is supposed to come up with that determination on their own. And you should be proactive and ask the insurance company, when are you going to come up with this value? When are you going to tell us? Again, it depends on the terms of your policy. On your end, you have the ability to push back on that and come up with your own valuation. This is where public adjusters can come up with it. The public adjuster really is the quarterback for having, they themselves may do it, or they may have licensed general contractors that they work with who will come up with a replacement cost valuation. They will walk through this. They will say, this is toast. You know, you've got to replace this altogether. You have to rebuild this, and they'll come up with an estimate. And then it's supposed to be that the insurance adjuster or their expert is supposed to meet and discuss your expert with your expert and try to reach an agreement. Now, if there's an amount that's not in dispute, so let's say you're saying it's, you know, 1.7 million and they're saying it should only be 1.3 million. Well, they should write you a check, assuming that you don't actually have to repair or replace, but for the 1.3, they can't just hold it hostage. But on that separate $400,000, you try to work it out. And if they can't work it out, then you could ask for an appraisal, or you could file a coverage lawsuit. The problem is, I mean, this is the problem. Litigation is expensive, and the carriers know that. And if they've been jerking you around and acting in bad faith, you may have a bad faith claim about it. But ultimately, it would be the court that resolves it in that situation. But the hope is you can get as close as possible. You do point to, you do imply a good point, which is, be careful that the carriers are going to try to lowball this, and they may be perfectly fine saying just clean something that they themselves would never tolerate. They would want everything ripped out to the studs. They want all the insulation in the attic and the walls ripped out, right? They may say, oh, that's not a big deal. We'll just cut a hole in the drywall. It's not going to do. So that's how the process works.
Helpful. And kind of back for a second on the expert thing. I know public adjusters, you said, are paid, obviously the percentage of the recovery anywhere from 5 to 10%. If you have to hire experts to deal with the degree of toxins or whether the house is inhabitable or not, any chance the insurance company pays for that, or is that on your own dime for sure?
You can ask them. I mean, they should be sending somebody out, and it should be part of the coverage if there's testing that needs to be done. You should ask them and say, look, will you send a tester out there? Now, look, the not so secret fact is that they're hiring people who are, being constantly hired by insurance companies. So you can kind of, without sounding too cynical, you can imagine where their bread is buttered. But you can see if they say something that seems crazy or not supported, you can go out and hire your own person, and then, tell them that you want to have a different opinion. They may not pay for that, but you should be prepared to do that if you need to.
Okay. One thing back in, I'm sorry, I'm just hopping around. I'm trying to figure out it's kind of rapid fire questions for you. If a dwelling payout is more than what you owe on the mortgage company in one case seems to want to hold that additional money. Are they allowed to do that?
I don't believe so. I mean, I've never encountered that situation. That's really more of a matter of not so much insurance law, but the rights of the mortgage company as to you. I don't believe they can. And most of the mortgage companies I've seen do want to cooperate with the homeowners. It's better for them if you rebuild a house. So they want to cooperate with you. If they put you in a situation where they're making things difficult for you, that's not in their best interest either.
Okay. And this has come up, and you hear a lot in the news, kind of differences between Fair Plan in California and other insurance companies, and kind of the so what of it. I know that's a super broad question, but are there particular things that people should be conscious of if they're in the California Fair Plan that might be different from kind of private, Allstate or Hartford or someone like that?
Yeah, I mean, the Fair Plan coverages are more limited. First of all, in coverage limits, I think it's $3 million. Maybe there might have been a little bump up for homeowners, and 20 million, I believe, for businesses. So whereas on the private market, there can be a lot more offered. Fair Plan, typically you have to actually rebuild or replace to get the full replacement cost, as opposed to some policies that will just write you a check for that. For the full replacement cost, even if you don't repair or replace. The limits, other limits like loss of use or contents, personal property, are a lot lower. There are some provisions that are a little bit specific to that, and they're more narrow. A lot of homeowners policies are what you call what you call an all risks policy. So they cover, they're a little bit more expansive, and they have some additional coverages that you might not get. You might have separate, for example, debris removal as opposed to something being included there. So you have to, and sometimes there are different boxes checked in terms of what coverages you get with your particular FAIR plan. But you generally just get a lot more and more expansive and generous coverage and better payment terms if you can get it on the private market.
Okay, fair. So I'm just going to read maybe if Dave, if you're okay, maybe we'll go another 5 minutes and then we'll go through a couple more questions. And then again, folks, if there are some of these questions were super, super specific, so I haven't done them here, but if you want to email them to me, I can ask David to see if he can respond to at least some of those. This one I'm reading kind of verbatim. For the older population who doesn't want to rebuild, can we get the full amount of dwelling and claim amounts? 2, still be able to sell our lot, and 3, still be able to win a settlement portion from the pending lawsuit related to the Eden fire.
Yeah. So, and I'll try to answer these questions pretty quickly. So number one, yes, you can rebuild elsewhere. Well, let me take that back. Whatever you do, it depends on the terms of your policy. If your policy says you get full replacement cost without actually rebuilding or replacing, then you can get that as a check. And the battle may be over what the replacement cost is, right? Just what we talked about a moment ago. If your policy says you get only actual cash value, you actually have to repair or rebuild or replace, then unless you rebuild or replace, including buying a place elsewhere, you're not going to get that full amount. Yes, you get to keep the lot. So it's basically you're getting whatever coverage you would get, whatever payout you get. Yes, you get to keep the lot. In terms of, I'll just quickly talk about these other lawsuits. So first thing is I wouldn't rush to sign up with any lawsuits. There may be class actions. There may be mass actions, class actions. The court certifies it. You're kind of bound unless you opt out. Mass actions are lots of individuals with a similar cause and they're dealt with differently. You want to hold off rushing into that because the lawyers will take a percentage and there may be better ones and the court may supervise it differently. Generally speaking, if you can pursue, if you're not made whole, there's this concept in the law, in insurance law, called subrogation. Subrogation, you may have heard of it. The basic concept is if the carrier pays you out and there's a third party that's responsible for this. So let's say everybody in the world agreed that DWP caused this fire, or Southern California Edison caused the fire, or whatever it is. The insurance carrier, by virtue of paying their claim, they actually use this term, steps into your shoes, kind of exceeds to your rights, and can go after that third party, basically, as you. There are some limitations on that. If you haven't been made whole, you are kind of first in line to get made whole. They can't kind of jump over you and get made whole. There's even some murkiness in the law about whether you can prevent them from doing that. But one of the key things you want to be aware of is, and you want to coordinate with the carrier if you were thinking about going after the third party, whether it's part of a class action or mass action or otherwise. What you want to be careful about is not do what we call impair subrogation rights. Okay, because the carrier stands in your shoes. If you were to go to a third party that caused this and say, hey, I'll settle my claim against you for $1,000 and sign a release, the carrier would arguably be bound by that. Again, simplistic version of the law. The carrier could say, wait, we were going to go after them for the $1 million or so we paid you. You impaired our subrogation rights. We now have a claim against you, or they could do other things that are not helpful. So if you are thinking about going against a third party, make sure you don't impair subrogation rights. Check in with the insurance company if they paid anything. Say, hey, this is what I'm thinking of doing. What do you think? Do you have any problem with my signing it up? And are you going to, dock me in any way or come after me? And force them to tell you, because if they say, no, everything's copacetic, go with it, then you should be in the clear.
Okay, super helpful. Looking, sorry, I just had it. One thing about, and this may affect, I'm not sure how many people, but may affect more than I realize. How does debris removal coverage in your policy, how how is that viewed in terms of the Army Corps of Engineer doing debris removal?
Yeah, so this is a common question because a lot of homeowners have received, opt-in notices. They can opt into that, which usually requires signing over to the county or the Army Corps of Engineers the cost to the extent you have any insurance. This is where you really need to read your policy and you need to communicate with your insurance adjuster and confirm things in writing. You should ask them what you should do, what they recommend. You have to be careful. If you have, let's say you have $150,000 for debris removal, and they're talking about that might be an individualized cost here. I mean, who knows what's going to happen? And that's the limit, and you're signing on to something, and the carrier says that's fine. And you're signing on to something where the Army or the county can go after your insurance, and it's a separate coverage, then you may be fine with it because it's kind of use it or lose it, right? And as long as you get it cleared up, that's fine. If, however, you have debris removal coverage that is part of your other coverage, of your dwelling coverage, for example, and it burns that limit, so you're reducing the limit that you have for dwelling coverage, you might want to think twice because you're kind of buying a pig in the poke. You don't, in a poke, you don't know if the Army's going to then stick your insurance carrier with a bill for, $300,000, I don't know, and reduce that limit. So you should really ask your insurance adjuster, say, hey, what do you recommend? What are you doing? Am I protected? What happens if, I'm burning limits? What do you recommend? They should respond and then document that. I mean, if they throw up their hands and say, I don't know, I don't have any idea, then you can consider it further, but you could try to pin them down and get their explanation.
Okay. And then any general advice about filing a claim for smoke damage outside the burn area? One person was noting they're 5 miles out, but still pretty significant smoke damage because they're along the smoke stream. Are you seeing either practically or legally a limit? Hey, beyond 2 miles, 5 miles, 10 miles, or is it a case by case basis? But the house didn't burn, but is severely impacted by smoke. How should we think about that?
It depends on the policy. I am trying to remember if there is some limitation in the FAIR Plan form on some distance limitation. I thought there might be, but I could be wrong about that. I just don't know off the top of my head. It depends on the policy, but generally speaking, smoke damage, unless there is some sort of a exclusion or limitation, that's going to be a fire loss, right? But you have to read your policy terms very carefully about that. And you should ask the adjuster, right? I mean, you are entitled to get from the carriers a coverage position in writing. In California, under the regulations, when you submit a proof of claim, not a proof of loss, which is a separate sworn statement they may or may not ask you for, but proof of claim basically means sufficient information for the carrier to make a coverage determination. The carrier has 40 days under the regulations, under the Fair Claim Settlement Practices regulations, to give you a position in writing under first party residential policy, which they can extend for, good cause and due diligence. And so they might do that here, but you're entitled to get that position in writing. And they have to tell you as part of that regulation, if they're going to accept part of your claim or deny part of their claim, they have to spell it out and they have to say why. So you can put that in writing, say, can you please tell us what the position is and give me an answer and tell me whatever coverage positions there are. And if they're going to deny it, they have to spell it out. So ask the carrier for that. You're not bound by it, but at least they'll explain.
And usually in my experience, they'll actually cite provisions of your policy, so you'll know what they're relying on. Like there'll be an exclusion or part of the deck or whatever it may be, but they'll cite a provision generally so you can see what they consider fire coverage, and they'll think fire damage is not smoke or whatever it may be. But no, that's very helpful.
Yes.
Again, I'm just gonna do a little rapid fire to keep you off balance, David, just for fun. One person said their insurance company said they could wait and see if the smoke clears before making a claim. Kind of, that seems strange. How should they think about that? Sounds like you're saying it's perfectly fine to make a claim early and contact them and let them know you have a problem.
Yeah, that actually, I don't know if that was implied, but that's actually a good question that I hear, which is, if I don't actually have damage, are my premiums going to be affected if I make a claim?
Yeah.
And really, look, I don't know for sure. There's underwriting is its own animal. I'm not an underwriter. At least from personal experience, I know that making a claim that doesn't result in a loss usually shouldn't affect your premiums if they're going to cancel you. It's for any reason. You should just, I mean, in terms of making a claim, you give them notice of what took place. You give them notice of these circumstances. So they're on notice. They may identify it as a notice of a potential claim. And if it turns out you actually have loss, then you would be, quote unquote, making a claim in the sense of actually asking for money to be paid or services to be, done to remediate that. So that's fine. But, you don't have to hold off doing anything, but you can just proceed, prudently.
Okay. And then I'm just going through it. Dave, if you're okay for a few more minutes, and we have not a ton more. So, and some of these are very specific, but if you put your house in a trust for estate planning, do you need to add the estate as an additional insured onto the policy? That may be more of an estate planning question, but thought I'd ask
Yeah,
you.
I don't know. I mean, it's really going to be the beneficial owner is typically who you put on it, but it also depends on the policy, what they identify when you say additional insured. Additional insured is usually done in liability insurance more than homeowners, because often in homeowners, they have a definition of the insured that may include, and you may have a loss payee, but I would just do whoever the beneficial owner is. But that's, really that is something at the underwriting process and the placement, you can ask the agent. The agent should ask the insurance company and when I say agent, either your broker or the insurance agent, and that's again something to get in writing. If you have a trust and you say who should be the additional insured, and the carrier writes back at the time of binding policy, no problem, just put such and such, and then something happens 6 months later, and they try to ding you for that, you can go back and say, look, I relied on what the carrier told me specifically, and there shouldn't be an issue there. So that's a further example of documenting something at the time.
Okay, and then this question goes to your partially is more relevant because of your comment that it's been really difficult for people to find alternative housing. People looking at hotels and apartments, everything. So someone asked if instead of renting, can you buy a condo to live in while you rebuild and collect loss of use funds rather than those funds going to a landlord?
Yeah, I've had this question multiple times. The short answer is I don't know for certain. The slightly longer but still short answer is the insurance company is probably going to say no. And the reason is that the idea of additional living expenses is it's really additional out-of-pocket expenses for you to maintain your current lifestyle. So if you buy other property, which is an investment, and you live in there, they're going to say, well, you're not paying expenses, you own it, this is a property, you don't have an issue. Look, the reality is from an economic standpoint, if you're living in there versus renting it out, you're having a loss, right? It's foregone rental income. It's the same thing as money is fungible. But the chances are that the carrier is going to say, no, that's not an expense. You can ask the carrier, but my guess is they're going to say no.
Okay. And then very specific question relating to section 2061 for the 4 months. My insurance company advanced me 4 months, but they based on the 12-month fair market value rate of my home, which was the lowest amount. E.g., the 1 month rate was almost double. I asked the insurance company to advance me the 4 months based on not less than the 4 month rate for my home, but they denied it. Is there any recourse?
Yeah, the recourse is to tell them is to write them back and say, this is what a comparable, first of all, you have to look at your policy. If your policy says we're going to pay for, a comparable standard of living, then that's what you point out. You can do research and show the comps, and you can say, this is what it costs. Now, look, if you're going to be hitting a limit, then it may not matter. But some of these, particularly private insurance company, private insurers, non-fair plan have very generous ALE limits. And we all know that the market value is insane. And again, this comes back to my comment that a lot of these adjusters or independent adjusters are not from around here. And so they don't even understand how crazy things are to begin with and even how crazier they are now. So write back to them, make a demand, cite the policy language, cite the 2061 or whatever it is, and tell them this is the proper amount. I mean, if they're still pushing back, you can file a complaint with the Department of Insurance and cite the language, just pass that on. and have them explain themselves and tell them you need to cite the law and the policy that shows, and tell them that their obligation is to tell you the law and the policy provisions that support their position. And if they can't do that, then, if they just say it's too much, but if the policy says you get an amount that's equivalent to the fair market value rent of your home at the time, then you're going to be stuck with that. So again, it comes back to the policy language.
Okay, very helpful. So a couple, maybe just one more, and then we'll wrap up. I guess one is for people, will their insurance be canceled after the fire loss is completed? Is this one of the things where the company pays the claim and then drops them, or how should people think about that?
I mean, you have the moratorium until early January next year if you're within one of these areas. But I don't know what's going to happen after that. It's possible. It could be that the Department of Insurance, the insurance commissioner, is going to figure out a way to allow the insurers to reset premiums if they stay in the market. But yeah, it's a real danger. And the California Fair Plan is, what did I hear, $377 million funded, and there's however many billions of dollars, tens of billions of dollars in claims on that. So it may be that the only thing you get is California Fair Plan after that point, but I don't have the crystal ball on what's going to happen.
Okay. David, thank you so much. So everyone, if I could just remind you, if you wouldn't mind staying on until I end the meeting. As I said, we're just trying to figure out if our license is working the way it's supposed to, and this will help people in the future as we do more of these large meetings. Again, I posted in the chat my email, paul.bokota, BOKOTA @gmail.com. If you send me an email, and David, there were some other specific ones, but not maybe 4 or 5 that we didn't get to, or in that range. And just put Zoom fire question in the subject, and I'll know, and then I can send them on, and we can see if we can get answers to at least some of those. So thank you everyone for joining. I very much appreciate everyone coming on. I hope this is helpful. I know this is a nightmarish time for a lot of people dealing with this, so I hope this is helpful. And David, thank you again. I know obviously you're given your practice, this is a super busy time for you, busier than you certainly ever wanted to be, I'm sure, especially under these circumstances. So and I think all of us greatly appreciate your taking time and making yourself available so quickly. And then for those, final thing I'll say on the call is most of you probably saw this. I know some of you may be from different Harvard alum groups or not Harvard affiliated at all, which is fine. But on the Harvard Club of Southern California website, we continue to update information. We have a document that's kind of a living document that we're trying to update, not just with any random things, but we're trying to, again, curate information that we think will be highly impactful to a large number of people. So if you kind of on a regular basis check that website, you'll see an update to that document. It'll have, mental health resources. We may have information about other things about mortgages. There may be some additional legal insurance information that we put on there. So again, we hope that will be helpful to people, and would encourage you to visit the website on a regular basis, as we are trying to update it in somewhat real time as we get more information. So again, I'm going to end the meeting, and then if everyone can stay on until I end it, that'd be great. And David, thank you again. I think we all very much appreciate you taking the time.
No, thank you so much, Paul, and really thank you all for having me. And I really wish everybody the best of luck. This is so difficult. So good luck and best for you.
Thank you so much. Take care, everybody.